If you want to come to the U.S. for a temporary stay, whether to visit, study, or work, you need to be admissible. If you're barred from entering the U.S. for a criminal offense, immigration violation, or another reason, you may need a 212(d)(3) non-immigrant waiver. Hello, my name is Dyan Williams, and I'm an immigration attorney. In this video, I'll talk about the 212(d)(3) non-immigrant waiver. When do you need it, and how do you get it? U.S. immigration law bars you from entering the country for various reasons. One of the most common is accrual of unlawful presence of more than 180 days following an overstay or illegal entry. Another is certain criminal offenses, such as drug convictions of any kind anywhere in the world. Then there is immigration fraud, or willful misrepresentation of material facts to gain immigration benefits. An example is if you lie about a prior overstay or fail to disclose it on a visa application. Some bars, such as the 310-year unlawful presence, does expire. Other bars, such as crime-related or misrepresentation-related grounds, are permanent. When an inadmissibility bar applies to you, the U.S. consulate will not grant you a B-2 visitor visa, an F-1 student visa, an H-1B worker visa, or any other non-immigrant visa. Likewise, a U.S. Customs officer will deny your entry if you're inadmissible, even if you have a visa in your passport, you're from a visa waiver country, or you're a Canadian citizen who's visa exempt. The only way to be admitted to the country if a bar applies to you is if you have a 212(d)(3) non-immigrant waiver and you're looking to come here as a non-immigrant. The 212(d)(3) waiver is not for intended immigrants who seek to live here permanently. Now I'll answer the four most commonly asked questions about the 212(d)(3) waiver. Question number 1. Do I need a visa with the waiver? The waiver is not a travel document. By itself, it does not allow you to gain admission to the U.S. Most foreign nationals do need a visa to enter the country. In general, Canadian citizens are visa exempt if they're coming here for a short stay as a tourist. The same goes for citizens from visa waiver program countries, but if you're inadmissible, you cannot use the visa waiver program. You do need to be either visa exempt or qualify for the visa itself in order for your 212(d)(3) waiver request to be accepted or considered. For example, if you are filing for a B-2 visitor visa, you do need to present evidence of strong ties to your country and non-immigrant intent. If you do not, the consulate will deny your visitor visa application under INA 214B. It will not even accept or consider your 212(d)(3) waiver request if you do not qualify for the visa itself. Question number 2. Do I qualify for the waiver? The 212(d)(3) waiver has flexible eligibility standards. Almost any non-immigrant qualifies for this waiver. The only time you're not eligible for the waiver is if you are found inadmissible due to foreign policy-related grounds, security-related reasons, participation in Nazi persecution, or participation in genocide. And these are very rare inadmissibility grounds. But just because you're eligible for the waiver doesn't mean you will get it. You still have to prove that you deserve it as a matter of discretion. Question 3. What must I prove to get the waiver? In your 212(d)(3) waiver application, there are at least 3 factors you must address. First, the seriousness of your criminal offense or immigration violation that makes you inadmissible. Second is your reasons for wanting to come to the U.S. And third is the danger or harm you would pose to the American community if you were admitted. When you present your waiver application, you want to include evidence of rehabilitation or remorse for a criminal offense. As for an immigration violation, you can show that this was a one-time incident that will not occur again and that your circumstances have changed significantly. As for your reasons for wanting to come to the U.S., they don't have to be compelling. In fact, if you just want to come here for a temporary visit as a tourist, you can still get the 212(d)(3) waiver, but the more compelling your reasons are, the stronger your waiver application will be. As for the danger or harm that you pose to the community, you do need to show rehabilitation or remorse for your violation and present positive factors that will offset the negative factor in your case. For instance, you can show community service, volunteer work, family responsibilities, as well as steady employment in a respectable position in your country. Question number 4. How do I apply for the waiver? You submit your 212(d)(3) waiver request at the U.S. Consulate at the time of your visa interview or after. If you're a Canadian citizen who's visa exempt, you may submit your 212(d)(3) waiver request directly with the pre-clearance office at the Customs and Border Protection. If you're submitting your application directly with the CBP, you normally need to submit a Form I-192 application form as well as submit a filing fee. If you're submitting your waiver request with the consulate, you normally don't need to submit an application form or a filing fee. But in all cases, you should present written testimony and documentary evidence showing that you qualify for the waiver and deserve to get it. It also helps a lot to present a legal memo or a cover letter explaining the facts, outlining the law, and showing how the evidence proves that you qualify for the waiver and deserve it as a matter of discretion. The U.S. Consulate will not forward your waiver request to the Customs and Border Protection for a final decision unless it first recommends it for approval. In most cases, it takes at least 4 months for the waiver process to be completed. On average, it can take 6 months, and in some cases, it can go up to 12 months. This is not a quick and easy process. A 212(d)(3) waiver grant excuses you from the inadmissibility bar, but does not get rid of it. When you're inadmissible and your waiver grant has expired, you will file for a new one to re-enter the country or get a new visa. Normally, it is valid for up to 5 years. A 212(d)(3) waiver is hard to get because you must present written testimony, documentary evidence, and an explanation as to why you qualify for the waiver and why you should get it as a matter of discretion. For more information on the 212(d)(3) waiver, hop on over to my website and read my article on this topic. If you need specific guidance or advice on the waiver application process, call me or contact me through my website at dyanwilliamslaw.com.